Hello, everyone. Thank you so much for being here at our Access to Justice CLE on Divorce Essentials. We're really excited to cover this, and we have some great presenters, so I hope that you're engaged and interested. If you have questions during the presentation, you can put it in the chat, or we can have some time at the end for questions also. So, I want to introduce everyone who's going to be presenting. We have Christopher Martinez. He's an attorney with Legal Aid Society of Salt Lake. Excuse me. We have Laurel Hanks, and she's an attorney with the Self-Help Center, and they're going to be talking about some volunteer opportunities that you have through those organizations and how the family law pro se calendars work. Then we're going to hear from Sharon Donovan. She's an attorney at Dart, Adamson, and Donovan. She has practiced law for over 40 years, and she's done it primarily in family law. So we are very excited to have her here with us and to share her expertise. And I think she's going to be a really great resource for you. Then we're going to be rounding out the session with Rob Jepson. He is a mediator who's been building his practice through networking and professional associations, and he's going to talk about the mediation process and how that wraps into family law cases. So we're going to hear from them soon, but before then, while I still have your attention, I want to invite you to consider serving by offering reduced rates. You can do this through the BAR's Modest Means program. And the way it works is a modest means lawyer, you get referrals from people who don't qualify for free legal help, but they also can't afford to pay the traditional fees that lawyers cost. They have to financially qualify for the program in order to receive referrals to you. So they cannot be above 300% of the federal poverty guidelines, but they also understand that they will be expected to pay for services and that a retainer may be required. So this is a really great way for you to get new clients and to try out family law if it's not something that you've done in the past. If you want to do that, the best way to find out about it is go to www.utahlegalhelp.org, and there is a tab for lawyers. Click on Modest Means and it will tell you all about the program, and we'll send out that link with the materials that follow the CLE as well. We also want to ask you to consider giving pro bono service through our new Utah Pro Bono portal. And that information is also on that same website. So we'll get that out to you. And with that, let's go ahead and hear from Chris and Laurel.
Okay, and I was going to go first. Can you hear me okay? I've got a little bit of tricky audio on my computer. Okay. I'm Laurel Hanks. I'm with the Self-Help Center at the court, and I was going to explain a little bit about the process of what goes on kind of behind the scenes, or what goes into this program. But before the pro se calendars, the attorneys at the Self-Help Center will send out notices to the people on the pro se calendars and ask them if they want representation. We'll email and text them and explain that volunteer attorneys are available, and explain that it's only for the court hearing, and explain that they're responsible for their cases before and after the hearing. We also make assignments based on conflicts. And so, you know, if legal aid has conflicts with certain clients, we'll assign them to the volunteers. We're also available if there are issues. The court clerks will assign the volunteer attorneys and attach them to the cases so you can see everything that's been filed in the case, but sometimes you need other things, and we're available to help with that. We're also kind of available to help with some other things, but I just want to say what a great program this is. We talk to people every day who are representing themselves, and we can help with explaining court processes and help with forms and things, but we can't give legal advice. And sometimes people just need to speak with an attorney who's been there and who understands where their case is going. And sometimes they need just a little bit of a check-in to see kind of what to expect. And so I wish this was available in every district. We talk to people all over the state. It's such a great program, and I really hope that you'll all volunteer. And I'll turn the time over to Chris.
Thank you, Laurel. And I do want to reiterate that this is a program that the court very much does support and appreciates the volunteers that come. And I don't think it's any surprise to anyone that the court also knows when they don't see people come. So it's a great way to score a few points with the court. I don't want to read from the website that talks about all the great things about the Pro Se calendar and really breaks it down simply because this isn't a Pro Se calendar CLE. But I do want to reach out and encourage anyone, especially new attorneys, especially if you have any mentees, to please come and volunteer at the Pro Se calendar. Legal Aid attends all of the Pro Se calendars, and anyone that is new and hesitant to do this for the first time can work with a legal aid attorney, can ask questions from a legal aid attorney, can get all of the help and assistance that they would need if they don't know family law from a hole in the ground. So particularly for new attorneys, I think it is a great opportunity in a very safe and supportive environment to get in some court time and experience. For more experienced attorneys, I really think it says a lot about the practice of law being a profession that we contribute back to the community and that we look out for the reputation of our profession by doing these Pro Se calendars. It's a way for attorneys to interact directly with the public when they need it most. And it is a limited representation opportunity. So you know exactly what you're signing up for. You don't have to worry about getting roped into more than you bargained for. And with that, I'd really like to turn over the time to the next presenter.
I think that's me. Good afternoon, everybody. I've been asked to spend a few minutes talking about just the basics of divorce law in Utah. Obviously, I don't have enough time to really do it justice, but I have some helpful tips, I believe, that you can look at after the presentation. In particular, the bar will be sending out the Utah courts link on divorce law, which is a very good outline of a lot of the topics they've asked me to speak about and which we don't have time to go into in detail. In addition, people have said, and probably Christopher agrees, that Legal Aid has the best divorce forms ever. And Stuart Rouse, the executive director of Legal Aid, has offered up those forms for individuals who might want them, and those would be available through the bar as well. So I just mentioned that because I think those are really helpful tools that you could use if, in fact, you're going to be taking a pro bono or a low bono case through the modest means program with the bar. Couple of things that just some general information that I'd like to talk about before we really get started in specifics. The courts have really gotten involved with some of the judges' help in trying to streamline the divorce process through the courts and try and make it faster. The statistics are that from people that these cases are just taking way too long. Kids are in limbo, parties are in limbo, and everybody has an opinion about how involved the court should be in our cases, whether it's Big Brother and they should get out of the way, whether it's helpful to set deadlines so that the cases are moving forward. But be that as it may, we have some new rules in place that basically force us, with the court's help, to move our cases a little bit faster. And I'll talk about that in a moment. So with respect to filing a complaint, we call them petitions. Somebody through the bar or through the court administrator's office thought that in a divorce case, having plaintiff and defendant was not user-friendly. So quite a few years ago, we are now petitioners and respondent. Whether that makes a difference, I don't really know, but that's how we start a divorce case. In terms of residency, the person or the other side filing a divorce action in the county where either of them live would have to have resided in that county for 3 months. And it's either the petitioner or the respondent, and that's an important thing. And if kids are involved, then the children typically would have to have lived in the county and the district for at least 6 months under some of our child custody jurisdiction provisions. In terms of grounds for divorce, there's a whole bunch of grounds. The most common grounds, however, are irreconcilable differences. It looks like there are 10 grounds, unless they've added one since the last time I looked. The most common being irreconcilable differences. The courts generally really don't want to hear about too many things. And for the most part, fault is really not going to get you too far in a divorce action. And although we have allegations of fault in our grounds for divorce sometimes, if there's some domestic violence going on that may have a bearing on custody, or it could have bearing on support. Sometimes we might plead in the alternative, irreconcilable differences, or in the alternative, we used to call it mental cruelty, mental and physical cruelty. There's other provisions for adultery, impotency, habitual drunkenness. And so there's a whole number of grounds that you can look at. Most of the time it's irreconcilable differences, or sometimes there might be adultery or mental cruelty. We have waiting periods that keep getting shortened. The waiting period from the time you file your petition for divorce and conclusion of the divorce decree is a month. And most cases are going to take that long anyway. And that used to be 3 months, and there's provisions for waiving that waiting period if it's appropriate. With only a month waiting period, I think that's kind of a waste of time and money, truthfully, if you're doing a modest means case. Let's see. When there are children involved, there are some divorce education classes that the parties need to take. There are 2 classes, a combination of 3 hours. You can do them online. The first one is a 1-hour class called the Divorce Orientation Class, and that's to figure out how to get divorced, and with a heavy emphasis on mediation, which Rob will talk about in a while, collaborative law, and the least favorable alternative is trial, but sometimes you have to go to trial. So that's the 1-hour class. Then there's a 2-hour class on education for parents about the do's and don'ts of dealing with the other parent, dealing with your children, not saying bad things about the other party, kind of the psychology behind how you should behave with your children, or I should say not behave with your children going through divorce proceedings, and truthfully post-divorce. A lot of times the classes are taught by mental health professionals, and the information is really quite helpful. As I mentioned, the divorce cases start with a petition for divorce. If you're doing a modest means case, the modest means lawyer can prepare those petitions. Like I said, there are forms that the bar can provide to you, so you don't have to reinvent the wheel. There is also some forms on what's called the Online Court Assistance Program, or OCAP, where people can file for divorce online, and they have a number of forms that supposedly are supposed to be helpful. It's kind of a cookie cutter, one size fits all case. Sometimes it doesn't apply to everything. Sometimes it can be very confusing and very long. But modest mean lawyers or pro bono lawyers can also help parties fill those forms out to kind of work them through the process. One of the things that is more new in the last few years that you should be aware of is that when a petition is filed for divorce, a domestic relations injunction is filed by the court. It's effective when the petitioner files his or her petition. It's not effective on the respondent until he or she has been served or has accepted service. And that's something that I think people really need to know about and make sure their clients are aware of it, because a lot of times they're not. I won't go into too much detail, but it's if you have kids, about do's and don'ts. You can't take the kids out of state. You can't say bad things about the other parent. There's a whole number of things dealing with children. As it relates to finances, there's restraining orders from disposing of assets, except for the necessities of life, paying your bills, your utilities, etc. So that's really, really important to know and to advise your client about. In terms of service of the petition, you can have service through a constable if you'd like, for a fee, and service needs to be effectuated within 120 days of the filing of the petition. A lot of people will, and this is usually my practice, is unless there's some domestic violence or some temporary restraining orders or something emergent, we'll see if the other side will sign an acceptance of service. I think that's the best practice in just the normal case. It saves time, it saves fees. And then once service is effectuated, an answer needs to be filed within 21 days if it's in-state service, or 30 days if it's out-of-state service. There's a big debate about whether people should be filing answers right away. And the reason for that is because of the court's involvement. Once an answer has been filed, normally would be 21 days. Both sides have to submit very lengthy financial disclosures within 14 days after the answer is filed. Now, in the pro bono and modest mean cases, that might not be that hard because there might not be a lot of assets. There might not be a lot of income or businesses that the parties have. But it's really important to make sure that the client knows, and probably when you first meet with them, and some lawyers say, before I file the petition for divorce, you have to have all of your disclosures done, because the deadlines come around really fast. And it's really, really important. And it's really important that you just don't rely on what the client says the assets are or the income is, because oftentimes they don't know. A lot of times they're being very secretive. And so you really have to take a pretty forward role in making sure that the disclosures are accurate. So those initial disclosures are really important. The other thing that's happened just recently, again, courts getting involved to try and move cases forward, is that after an answer is filed, and sometimes even before the initial disclosures are due, the court is scheduling what's called a case management conference. I think I have one this afternoon actually with Commissioner Loon. I think mainly doing them by WebEx because they're short. And the case management conference talks about 3 different tiers of divorce cases. The really simple one, how much time do you need? Maybe no kids. Cases that have kids, cases that have a lot of assets and kids, how much time do you need? And the goal of the courts is that you don't leave one of those case management conferences until you have the next court hearing scheduled. And that can be an added cost, an added hassle, but that's the goal of the courts trying to move the case forward. And depending on the track that it is, the court will set specific deadlines for when you have to do certain things. The other things that happen quite often is that temporary orders need to be prepared, like who's going to live in the house, who's going to have temporary custody of the children, who's going to pay what child support, what bills, all of those sorts of things. And it is very, very common that a motion for temporary orders would be filed. I'm not sure if this is still true, but when kids are involved, previously, you couldn't ask for a motion for temporary orders until you took the divorce education class. I don't know if that's still true. And those temporary orders are heard before our court commissioners, and that's a whole other system that I'm not going to go into right now because we don't have time. But if you go to these forms and the domestic relations commissioners, you can see what that process is. My understanding that post-COVID, most of these more substantive hearings are being heard in person by the court, and more of the scheduling hearings like case management orders, pre-trials, etc., are still being held through WebEx with the court. A couple other things I want to mention dealing with divorce cases is social media. Social media is an absolute no-no, and you need to tell your clients not to put one darn thing on social media because it always shows up in the divorce case. People think they're invisible. They put their whole lives on Facebook. They need to not do that. And the other thing that it's very common, the other side either knows your password or will guess your password because you've been married for a long time and start looking at all your emails to your attorney, to your boyfriend, to your whomever, your sister. And you really don't want to do that. You want to have, and some people will recommend just go get a different secure, maybe Gmail account with passwords, usernames that the other spouse couldn't possibly guess. The other thing that is really quite common in any case, but particularly the pro bono and low bono cases, is domestic violence. There's just a lot of that. There's a whole psychological facet that happens with those types of cases. Legal aid handles a lot of those cases. We have protective orders that the commissioners hear, and that's just a whole nother area that you should be aware of if there's domestic violence or child abuse. In terms of, so those are some of the things that I wanted to mention. In terms of support, we have child support that's based upon the gross monthly income of both parties. We can impute income in certain cases. And usually it's for a full-time 40-hour work week unless there's historical second-time work. And you can read about that. For alimony, we have alimony. Basically, it's a need and ability to pay. And there's a whole number of factors that go into that you can read about through the divorce, Utah Courts Divorce Online information. In terms of children, we have a presumption of joint legal custody being in the best interest of children. That's different than physical custody, or can be different than physical custody. Physical custody is more of the how much time do you have. It doesn't have to be 50-50. A lot of times it will be 50-50. And whenever you have a case where children are involved and joint custody is requested, you have to have a parenting plan. And there's a lot of different forms for parenting plan. You got to have a dispute resolution provision in there. You need to have, provisions for parent time, decision making, those sorts of things. And that's a pretty complex thing. In terms of assets, we are an equitable distribution state, which does not need to necessarily mean equal. A lot of times it does mean equal, but the result needs to be fair and equitable under the circumstances. In terms of retirement accounts, even with low bono or pro bono, a lot of people will have some retirement accounts that need to be divided. If there are 401ks, typically what's called a qualified domestic relations order, or QDRO, is prepared separate from the divorce decree to divide those plans. The idea is if you divide a 401k, one party gets half, the other party gets half. And these QDROs are important because those are transferred with no tax consequences to the party until they are withdrawn. And that's a really, really important thing to know about retirement plans. There are some individuals who will prepare QDROs. And again, for the pro bono and low bono, I don't know who might do those on that basis. But and the different plans, say you work for American Express, they typically have sample QDROs that you can use. If there are IRAs, that's different. Typically, all you need is a transfer form to separate IRAs, so those are pretty simple. The 401ks, 403bs, all of those things require a QDRO or a little bit more involved. We have mandatory mediation in every case, which is that's if you don't otherwise settle before then, which is a really great thing. And Rob's going to talk about that in a minute. I believe, since this has been implemented with really great mediators, Rob's a great mediator, we have retired judges who are great mediators, and a number of other mediators who are very experienced in high conflict cases. And I would say probably about 9 out of 10 cases these days settle in mediation. Very few cases go to trial anymore. We used to do trials, 2 or 3 times a month. I probably haven't done a trial in 4 or 5 years, which is great because they're very stressful, they're very unpredictable, they're very expensive, and nobody's happy. I'm not sure people are happy with mediation, but I think they're more happy if they feel like they're involved in the process. So with that, I'm now going to turn the time over to Rob to talk about mediation.
All right, thanks, Sharon.
Can say, hold on. Yeah, 1 second. There are a couple of questions that haven't been answered that have been coming through the chat. So the first one was about the divorce education classes. And it's, if you do not have children, do they need to take the first hour of the divorce orientation class?
No.
Okay. And then it looks like the second question is, am I correct in understanding that no QDRO is required if each party retains their retirement without division or sharing?
Correct. Good
Okay.
questions.
I was going to say, excellent. Thank you so much. And now,
Okay.
Rob, sorry, go forth.
Oh, that's great. Thank you. And hello, everyone. So I'm Rob Jepson. I'm a full-time mediator. This is all I do. And it's the best. Mediation is the best. So I think part of the purpose of this CLE is to convey to everyone just how easy it is to volunteer to do a pro bono case. Is that correct, Pam? So it's so easy, right? Super, super easy.
I was gonna say, of course, we always give plugs for pro bono and for modest means, but it's also to get people to understand how to do the process, especially when they're starting out.
Okay, love it. Well, in both cases, I think mediation is something that truly makes the process easier. Whether you're a veteran family law attorney or someone starting out or doing a pro bono case. I really think mediation makes the process easier because it creates this moment where you get to pause fighting and everybody comes to the table and you see if you can just talk through all this stuff and work it out. Mediator's job is to help find a resolution. And like Sharon said, it almost always works. I think statistically, it's like 85 or 90% of the time mediation works, which if we'd known that when we founded this country, maybe we would have like put more mediation in the Constitution. I don't know. It's a pretty great statistic, I think. Okay, I wanted to talk about just a little bit of the mechanics of mediation. So like Sharon said, mediation is required before a case can go to trial. So unless you settle on your own through direct negotiations, you're going to end up in mediation, which is great. Mediators are typically trained in the law or at least have had a lot of exposure to the law and know the issues well. So if you're a new family law attorney or if you're volunteering, you've got a third person in the room who can help guide the discussion. Mediators, just like attorneys, do have different personalities. So, you know, without naming names, I've got some categories of just different types. Some mediators they view their role as being just relayers of information. It's a more passive diplomatic approach to mediation. It's just to keep things calm and prevent mom and dad from killing each other. Other mediators are more involved where they will take an equal role in the negotiation process and help talk through the issues and brainstorm and kind of shape the way things are going. And some mediators who are retired judges or otherwise very experienced can be more directive. They can be very efficient. You're just like, here's what we should do. In all cases, mediators are not supposed to be advising the parties. We're not attorneys, we're not advocates. We're just there to help. So the burden is really on the attorneys to give the legal advice and to give direction to their clients. Mediators are just there to help set the table and do whatever they can. If you are working on a case and you need to schedule mediation, there are a few steps. First, you would reach out to the opposing counsel or to the opposing party if they're unrepresented and just acknowledge that you need to do mediation. Second step, whether it's been mandated or whether it's because you're wanting to go to trial. Second, you pick a mediator to work with. I think your best friend there is either Google or the court's website has a list of all the approved mediators. I don't know if Legal Aid or other organizations also have a public list. Okay, Google and the courts are your friends there, or word of mouth. And then you schedule a date with the mediator. That might be the most time-consuming part. Just getting 5 people's schedules to align, 2 clients, 2 attorneys, and the mediator. But most mediators have like an online calendar to try to make that easy. On the day of the mediation, there are a few different format options. If it's over Zoom, you could all be in one Zoom room together, or you could be in separate breakout rooms, and the mediator goes back and forth between the breakout rooms. That is most common because, let's be real, most people who are divorcing, it's not constructive to have them in the same room. And then ditto for in-person. If you're doing your mediation in person, most commonly you'll be in different rooms and the mediator will go back and forth. Although sometimes, and I'm sure the attorneys on here would agree, sometimes you put everybody in the same room and it goes great. Or at the very least, it's very entertaining, a very, very exciting dynamic sometimes. On the day of the mediation, you're generally seeking a global settlement. So all of the issues that we've talked about today, child support, custody, alimony, property division, quadros, parenting plans, et cetera, the goal of mediation and family law is to get a global resolution. So again, I just think it's such a great opportunity to get the whole thing done And again, if you're new to family law, you've got a group of people there who all know all of the issues and can help bring it to a conclusion. Echoing what Sharon said, it pays to be prepared for mediation. If everyone comes to the table with no data, it's a little bit hard to negotiate. If nobody knows what the house is worth or what the cars are worth or what everybody's incomes are, that makes it very difficult to negotiate. Unless you've got parties who happen to trust each other, intrinsically, but that doesn't happen that often. So it's really, really helpful to have pay stubs, tax returns, W-2s, a market comparison for the value of the house, and if you want to be an A+ student, you could get an appraisal on your house before coming to mediation. In terms of timeline, mediation can sometimes take 2 hours and you get a full deal with signed papers and everything. Sometimes it goes 12 hours and you get nothing. So, budget liberally, I would say. It's better to budget more time than you think you'll need. It's always really sad when we spend, 6 hours in mediation and we're almost done and then someone has to leave, because typically the engine kind of loses steam after that. It's hard to bring people back to the table a week later and pick up where you left off. So generally speaking, it's good to get it done in one day. The product of mediation is you do get a signed agreement. So typically the mediator or one of the attorneys will draft the agreement, and then everyone will work together to go through it, finesse it, do any little micro negotiations to clean it up, and then everybody signs. If you're new to family law, that's not the very end of the process, because you still have to file it with the courts and file all the other things that a judge needs to sign off on. But for purposes of negotiating, the signed stipulation it's kind of the end of the process. You're done fighting after that. Hooray. The last thing on my list to talk about was payment. There are mediators who will do a sliding scale for legal aid cases or other pro bono cases. I don't have a list of who does sliding scale and who doesn't, but it is out there. Absent a sliding scale structure, mediators charge anywhere from $50 an hour to $350 an hour. That's typically split between the parties. I would say most mediators are in the $200 to $250 an hour range. And again, the parties split that. And if you're working with a family law client for the first time, it's important to convey to the client that they're responsible for that bill. Typically, the attorneys don't pay it from their retainer. Every now and then you get a client who looks at the attorney at the end and says, "I thought you were going to pay for this." And the attorney says, "Nope." And the mediator has to sit there awkwardly waiting for them to work that out. So it's good to let the clients know ahead of time. Let's see what else I have on my list here. I think that's it. So mediation's the best. Everybody loves it, or at least I love it. And I think we can do some Q&A, and that could be about mediation or just about anything.
Well, maybe, Rob, I had a couple of questions, frankly, for my own information about you. What type of mediator, how would you describe your style in mediation?
I'm probably in the middle. I'm not a very passive mediator. Some mediators really believe that it's their job to simply relay information. And I just get really bored doing that. I like to get involved, and I like to connect with the clients. I like to listen to them and understand them on more of an emotional, personal level. I don't like to stay in that zone for very long because it's not productive, but I like to understand their pains and where they're coming from. And then I go to the other side and do the same thing. What are your pain points today? What are you worried about? And then I try to participate with the attorneys in coming up with solutions and, trying to think our way out of the woods. Every now and then, if a client and I are really connected and we have a good rapport, I can be hard on clients. I can say, like, sorry, you've asked for this, you've asked for X 6 times in a row. 6 times in a row, the other side has said no. So I think you need to stop asking for X. I can be direct with the clients if that feels constructive, but I don't come out swinging either. I know some mediators are very, very, very direct and they push the deal through, which I think sometimes that's necessary. I'm just not old enough or gray enough to get away with that.
Right. What do you do if, how do you reality check the clients or the lawyers if they're just taking, like you were talking about, positions that are just not going to go anywhere? What's your style on that, Rob?
If it's a client, I'll say, well, generally speaking, that would be considered outside of a normal agreement. There might be some issues with what you're proposing, such as A, B, and C. So I really think that's outside of the norm. That doesn't mean it's impossible, but I wouldn't anticipate the other side agreeing, especially if they're represented by an attorney, because it's so far out of the norm. Try to just let them down soft like that. If it's a highly animated client who doesn't want to listen to anyone, and I'll tell them like, hey, I get what you're asking for, but the bottom line is it's not going to happen today. So let's move forward. With attorneys, I just very respectfully say something like, oh, that wasn't my understanding of how the law works. Because I'm new. Say, help me understand why you think the law works that way. I haven't heard that before. But generally speaking, I think attorneys are right on the money, and I just, there's not really that conflict most of the time.
The last question I have, and then I'm going to quit asking questions, is what do you like written materials ahead of time, so that, like a short mediation brief, maybe some financial declarations, pay stubs, etc., or not?
I like a really brief, like a 1-pager or a 1 or 2-pager, just to get oriented. But I think I'm speaking for most mediators. I don't spend an hour preparing for each case because nobody's paying for that hour. And I think there's something to be said for just coming into the room and reading the room before you start getting really steeped in the facts. So I like a 1 or 2-pager, but most of the time most people don't offer to do a brief.
Thanks, Rob.
Yeah. That was fun. Thanks for letting me talk about myself.
Gonna say, well, there's some more questions for you, Rob, that have come through the chat. So the first one is, what is your experience with divorce mediation where the other party is unrepresented? What advice can you offer to the group?
Yeah, as a mediator, I actually love that dynamic. I really like working with pro se parties because they tend to be more outcome oriented. They tend to be thinking more about the day-to-day of their life, and they tend to be thinking more about, like, how can we get out of here and still have a peaceful dynamic between me and my ex? Sometimes attorneys, because attorneys are highly trained in the rights of the clients, sometimes attorneys will feed the clients with, what's the best case scenario they could get? What's the highest level of rights that they could assert? And obviously that's a good thing to do, but occasionally that will create even more conflict because it changes the client's mentality from what's a good fair deal where we can leave as friends to, oh no, I don't want to leave with less than I could possibly get. That's a delicate dynamic. And I just see value in both. 90% of the cases I work on, it's 2 attorneys, attorneys on both sides. 10% of the time, it's either 1 unrepresented client or 2. I think as a mediator, when you're working with a pro se client, you have to be very careful because you can give them the general lay of the land. You can tell them what's a normal outcome. You can tell them what you've seen a lot, but you can't give them advice. And that's really tricky. So I think with pro se parties, probably my most repeated sentence is, this is not legal advice, but here's a common parenting plan. This is not legal advice, but if your house is worth $400,000, typically that equity would be divided between the parties, that kind of thing.
One other possibility for pro se parties with mediation is that you try and schedule a mediation through the pro se calendar where a volunteer attorney could be with that other party. So if you have a case where you're concerned that the case may not move forward very efficiently without an attorney to help the unrepresented party, then oftentimes you can schedule a mediation through the pro se calendar and have a volunteer attorney assigned to that unrepresented party.
Amen.
So another question is, how different or similar are mediations that do not involve divorce, but are unmarried couples with children?
Yeah, so with, okay, we're asking about kids versus no kids, right?
Well, so
no. Married
versus unmarried parents who are trying to get custody.
Yeah, my understanding is that for attorneys, the life of a parentage case is pretty different than the life of a divorce case. I would say for mediators, it's pretty much the same thing because it's all the same issues. The only difference is at the top of one document, you say the parties have irreconcilable differences and are seeking divorce. And in a parentage case, you don't put that. So I think the mediations are pretty similar. Yeah, short answer.
And then how much do you charge per hour? And do you draft the final stipulation or do you rely on attorneys to draft it?
I charge $560 an hour. I'm just kidding. I charge $200 an hour, which is pretty normal. I do draft, but again, I do the first draft and then I go back and forth between the two rooms and give everyone their say in the editing process. And that can be a really quick process, or it can take an extra 2 hours. And yeah, I do. Yeah, I work with pro se litigants often.
And then this question for Rob and actually for Sharon of what's the best way as you're trying to build up clientele and as you're trying to get started in the industry? Like, how do you get clients? How do you start to get comfortable? What advice do you have? So Rob, why don't you go first, and then Sharon, if you can jump in.
Yeah, I'll be really brief because Sharon has built a legacy and an empire. I want to hear. My very brief answer is starting anything takes a lot of bravado, and it takes a lot of relationships, and it takes a lot of volunteering. Just putting yourself out there. That's kind of all I have to say about it, if that's okay.
Yeah, I agree with Rob. I think that going out on your own early on in your career is a pretty intimidating process. And some people do that and they do it quite well, but they also market themselves quite well. They will volunteer at the pro se calendar, or I don't know what they're doing anymore, the family law clinic, or these volunteer. We used to have Tuesday night bar. I'm not sure if we have that anymore. But making yourself seen, having the commissioners recognize you as somebody that's going to give back. And they often, a lot of times lawyers will say, who are some of the best young lawyers? Because we want to hire them, or, whatever. And the commissioners, sometimes the bailiffs are really good at that too. Who are the best ones? Who has the best style? That sort of thing. For me personally, I started at Utah Legal Services when I started. And for some reason, they put me in the family law department. And that's where I learned to do some low income family law cases. And I really liked it. I felt like, I felt like it's kind of like being a lawyer. Well, it is being a lawyer, but it's also kind of like being a therapist. And some people, it's a good fit, and some people it's a disaster. They just cannot deal with the emotions of it all. For whatever reason, probably, just because I let things kind of fly off, it was a good fit for me, although I really do care about the clients. And so I think legal aid is a wonderful place to get a lot of experience. A lot of lawyers will hire legal aid lawyers in their family law practices because they're trained so well. And so I think that's a great way. Doing volunteer work is a great way. I think trying to work for a family law firm that does a lot of family law as an associate. Sometimes I've had a few people that will just volunteer their time just so that they can get some experience. And it's amazing if you do that, how it evolves. Because if you have somebody do that and they say, boy, that person's really, really sharp and that person really cares about this, a lot of times it turns into a job. And so those are just some things that I would say. practical experience is invaluable. It really is. And so those would be the things that I would say. I actually, and maybe Pamela, you can speak to this. Yesterday, I got an inquiry from, I gathered kind of a newer lawyer that's trying to start her own family law practice, and was really discouraged that the low bono cases were taking away from her clients. And I don't know, I guess I've learned today that you have to be less than 300% of poverty level. Whether that would be a case this person would take on a low bono basis to kind of get some experience, or whether they're just not able to afford that. They need a client that is more of a full pay client. And Pamela, I don't know what you would say about that, or if you have any thoughts about that.
So I think one of the things that the Reduced Rate Services program tries to do is meet access to justice needs, balanced with providing these kinds of opportunities to our legal professionals, whether it's lawyers or licensed paralegal practitioners. And that also factors into that side of who's paying for services, where can they afford them, and how is that diffusing some of the business. But I think ultimately we will help find the right fit for the lawyers as well as for the public who's coming to the office trying to get help. And we are happy to answer those questions and talk to people one-on-one to help them get the information that they need and to deal with that.
If someone takes a low bono case through modest means, how is the fee set? Is it their flexibility with that lawyer, or does the bar set it?
So the program is set with fees to an extent. Basically, someone has to qualify, and then based on their qualification, there are two tiers. They either can charge $75 an hour or $50 an hour if the person's very low on it. But there is some flexibility because the program does allow for flat fee services. So if it's not something that fits in the typical scenario of wanting to charge hourly, like they just want a letter written or they want an attorney to come to a hearing, you can do that as well. And those just need to be at 35% of your traditional fee that you would charge.
I think it's worthwhile to point out also that many private attorneys do pick up clientele at the pro se calendars. If there's a reason why someone hasn't hired a private attorney already, and they like the service that you provide for them that day, they're most likely going to ask you if they can retain you. And I know a lot of private attorneys that have found a lot of great clientele that way.
It looks like we've had, it looks like we've had a couple other questions that have come through. So be sure to leave time for them, but go ahead, Sharon.
I was just going to say something. Oh, the pro se calendar is not income defined, right, Christopher? Okay. So it wouldn't necessarily mean if you go to the pro se calendar, that parties wouldn't necessarily have income or jobs to pay for a private lawyer, right?
Absolutely.
Okay, thank you.
Okay, so a couple more questions. A common scenario I've seen are clients who want more parent time with the child, but they live a lot further away from the child's school than the other parent. How can parties work towards an equal sharing of parent time under those dynamics where one parent can easily accommodate school needs and the other parent cannot without significant expense? Any thoughts?
Rob?
No one wants to answer that. But these are the hardest cases, right? And again, I can only answer from a mediator's perspective, but if you have two good, willing parents, but they live 200 miles away, there's no way to do 50-50 unless one of them is like a pilot. So those are the hardest cases. So I think in those situations, you're making the best lemonade you can out of the lemons you're given. You know, if mom has the kids in Moab during the school year, she's the primary parent, dad lives in Logan, maybe he gets more time in the summers, maybe he gets all the 3-day weekends. Maybe you make the most out of virtual parent time and FaceTime. But maybe they get a little bit more of the winter break. I haven't found an easy answer to those situations. Those are really tough cases.
Or maybe you move.
Yeah, Sharon cracked it. Yeah.
It looks like there's another question. Could Sharon talk a little bit about proffer hearings and the difference between a proffer hearing and an evidentiary trial?
Okay. Well, a proffer hearing is normally what we do before the commissioners, sometimes by agreement with the judge, but say the commissioners. And that's why it's basically the lawyers that are proffering what their client's testimony would be, or third parties' testimony would be. And you have to file those declarations or affidavits with the court in order to proffer what the testimony would be. You can't just show up and say, well, my client would say this when the other side hasn't even been notified or the court doesn't even know what you're talking about. Now, some people call the proffer hearings liar's court because there's no cross-examination, you can object, and sometimes it's really hard to figure out what the truth is. But that's the best system we have, given the limited resources we have. As it relates to an evidentiary hearing, that could be before the commissioners if you do one of those informal trials, or before the judge on some sort of an evidentiary hearing on a contempt issue where you do have to have testimony of the order, did they know it, did they willfully violate it, all of that. And that would require actual live testimony where the client gets on the stand, swears to tell the truth, you question the client, the other side gets cross-examined, the court might have some questions. And so that's like a real live court hearing or trial, unlike just proffering what your client would say.
All right, it looks like that's all the questions that we've got in, and we are just about at time. So everyone, thank you for being here, and to our presenters, thank you so much for coming and sharing your expertise with us.
You're welcome.
Thank you.